Hi, good morning, everyone, and thank you for coming out on this dreary gray morning. My name is Celeste Arrington. I'm the director of the GW Institute for Korean Studies and the co-director of the East Asia National Resources Center here at GW. I'm also a professor in the political science department. It is my great honor and pleasure to welcome you to this year's GWIC Signature Conference, which we're pleased to co-host with the East Asia National Resources Center, the Seeger Center for Asian Studies, and the Taiwan Education and Research Program here at GW. It's also a great pleasure for me to welcome our speakers all the way from Taiwan, Korea, and Japan today, as well as our local speakers. Today's topic is disability rights in East Asian democracies, and we will, through the 6 speakers, 3 panels, explore how understandings of disabilities and the rights of persons with disabilities have been changing in East Asia. Also, how the legal frameworks that protect or otherwise don't their rights, and how the lived experiences of persons with disabilities is changing. Also, interactions among all of these changing processes. In what ways, we're going to ask, and through what means, have disabled persons organizations, their families, civil society organizations, and lawyers affected these processes of changing rights of persons with disabilities in East Asia. We're also in particular going to look at the impact of the Convention on the Rights of Persons with Disabilities, or the CRPD, in Asia, how disabled persons organizations and other disability rights advocates are interacting with and strengthening and deepening the CRPD, if you will, the CRPD in action on the ground in East Asia. How are they localizing or vernacularizing concepts of rights that are enshrined in this convention? How are they interacting, using the CRPD to interact with existing institutions and laws on the ground? And how are disability rights advocates being empowered by or also strengthening the CRPD at the international level, including through UN compliance monitoring mechanisms? So our broad topic for today is really to focus in on what differences the CRPD and other rights concepts are making in the lives of persons with disabilities in East Asia. So again, these rights in action and in the lived experiences of persons with disabilities. As you can tell, since I'm one of the presenters, this topic is near and dear to my heart, and so you'll hear much more from me later. But let me first ask you to join me in thanking our GWIC staff and especially the NRC staff for today. Lisa and Bobby spearheaded the logistics of today's conference, as well as received support from the Seeger Center and the TERP staff. So please join me in thanking the staff for today. In order to welcome our interdisciplinary group of speakers, experts today, I'm going to welcome to the podium Dr. Lisa Lackney, who is in charge of the East Asia National Resources Center and has been the brains and brawn behind the organization of today's conference.
Thank you all for coming today, and thank you for that very kind introduction, Celeste. I'd like to introduce the 2 speakers for our first panel today. First, we'll be hearing a presentation from Lee Sooyeon. She has been working as a public interest attorney in the field of human rights in Korea since 2019. She majored in education in college, so she's very interested in the right to education and is working to ensure the right to education for children and youth with disabilities, remedy discrimination, and amend relevant laws. As a public interest lawyer, she is mainly engaged in litigation, law reform, and international solidarity activities. She has worked on cases of discrimination against persons with disabilities and has worked to change laws related to the right to vote and education. In international solidarity activities, she participated as a member of civil society in the deliberations of the Committee on the Rights of Persons with Disabilities in 2022 and the Human Rights Committee in 2023. Currently, she works for an NGO called NOW, Network for Organizing and Widening Pro Bono Activities, which not only works in the field of disability rights, but also supports networking for public interest lawyers and promotes public interest lawyering in Korea. Our second speaker on our first panel is Maeda Mayuko, a PhD candidate in political science at the George Washington University. Her research interests include disability rights movements, transnational activism, and Japanese politics. Currently, she is working on a project examining the voting rights of people with cognitive disabilities around the world. She is from Tokyo, Japan, and received her BA in political science and Russian from Grinnell College. So again, please join me in welcoming our speakers, Lee Sooyeon and Maeda Mayuko.
Hello, I'm a public interest lawyer from Korea. Actually, the original script I prepared, I said I'm a public lawyer from a whole new spring day. However, the political situation in Korea has been dynamic in recent days, so the script has to be changed in just a week. It seems that I will have to wait a little longer for a complete and true spring to Korea. Some of you may heard the news from Korea. I might, I might not have been here with you today depending on the decision of the Constitution Court. I remember the phrase ban on traveling abroad in a modern and contemporary history textbook, and I'm so glad it didn't come true. Before I start my presentation, I have something to say. I actually have a stage fright, so I'm very shy person, so please don't be bothered, even though I can make eye contact with you during the presentation. When I work as a public interest lawyer in Korea, I often have to give press conference and go to protest site and give presentation. But as an internally oriented person, I need to recharge my energy at home after work. Nevertheless, I'm standing in front of you here because it is a great pleasure to meet people working for and having an interested of disability rights. The experience I'm pleased to share with you today are the works with my colleagues. They are lawyers, activists, and persons with disabilities. They are really lovely, but sometimes what I have to say to them is, let's just have some meal, not talk about work anymore. Just enjoy the meal. Occasionally, generally, they don't give me time to cool down. Anyway, the first case I would share with you today is discrimination against the right to vote for persons with intellectual disability. In Korea, various efforts has been made to guarantee the right to vote for persons with intellectual disability since 2014. With the introduction of pre-voting in the 2014 election, disability organization began monitoring the accessibility of election. According to statistics at that time, the accessibility of election for persons with disability was just less than 50%. Disability organizations have held several meetings with the National Election Commission, the agency in charge, and they have requested that the necessary accommodation be made to guarantee the right to vote of persons with intellectual disabilities. Since 2016, disability organizations have held dozens of press conferences and campaigns and public petitions to raise awareness of the importance of the right to vote for persons with disabilities. Since 2020, we have been campaigning for the revision of Public Official Election Act to provide ballot with images and easy read version of election leaflets. Despite all of these efforts, the Korean government still has not provided specific and practical measures to ensure the right to vote for persons with disabilities. Therefore, in January 2022, we filed a lawsuit with two plaintiffs to prohibit discrimination against persons with disabilities in election and remedy their rights. Our claim were to create manual for producing easy-read version of election materials and to provide ballot with images such as party logos and candidate photos. While in the first trial was in progress, Korea was deliberated by the Committee on the Rights of Persons with Disabilities. Korean disability organization prepared and submitted parallel reports, invited and country reporters, and asked for some feedbacks. And the advice from the country reporter was to prioritize and organize the key issues. However, it's always difficult to set priorities. Therefore, there are many discussions and debates within and between organizations. In Geneva, we distributed lobby papers and monitored deliberation in other countries to identify the topic of interest to committee members. We also email the committee members individually by their interest and went to them in break time to give them our opinion directly. After the review, we compile our proposal for the concluding observation and deliver them to the Secretariat and the country reporter. We work hard to convey our voice to the committee and have our opinions reflected in concluding observation, even if we had to cut short our sleep. But when the concluding observation were released as a result of that summer, we were so touched and happy. This is the part of the concluding observation. They said the committee recommends that the Korean government to guarantee that electoral and voting procedures, facilities, and online or printed election materials are accessible in plain language and easy read, thereby facilitating their use by all persons with disabilities. Despite receiving this successful concluding observation, the first trial was dismissed. This is because the court judged that the guarantee of voting rights for persons with disability cannot be reserved through the judicial proceedings because it is legislative matter that require the revision of the Election Act. However, there is a law in Korea that prohibit discrimination against persons with disability and provide remedies for their rights. Article 48 of the Act clearly regulates the court's remedies. It said the court may render judgment to discontinue a discriminatory act and also to take proactive measures to rectify such act. So we appealed the court decision criticizing the court's lack of understanding of Anti-Discrimination Act and disability rights. During the second trial, the National Election Commission published a guide for producing election materials in easy read. So we withdrew the request to produce some easy read manual. And also during the trial, the Korean government continued claim that it would be cost a lot to produce ballot paper with images. So we added a claim to produce and provide voting ads with image. Afterwards, the second court decided to provide voting ads with images for persons with intellectual disabilities. I still remember clearly that the moment when I heard the sentence at the trial, my heart is so pounding with It's what the judge said. But unfortunately, the case is not over. Korean government has appealed, so the case is waiting for the Supreme Court decision. The second case is the suppression of the right to liberty of movement and freedom of assembly. In Korea, persons with disability are not fully guaranteed the right to movement. In 2023, when the Committee on Civil and Political Rights were deliberating on Korea, the percentage of wheelchair accessible buses was only 30% on average across the country. And there are only 2 wheelchair accessible buses among intercity buses nationwide. In the case of Seoul, there are many tragic deaths due to inadequate transport facilities. Persons with disability and civil society organizations continue to their rallies for the rights of persons with disability, but they are under oppression from the government and violent suppression of rallies through excessive use of force, indiscriminate arrest, and prosecution of rally participants were unprecedented. While preparing for the deliberation, civil society, disability organization, and lawyers gathered to write parallel reports. At that time, due to lack of funding, most of people who participated in the writing could not go to Geneva since it costs a lot fly from Korea to Switzerland, so it is difficult for members of small organization to go to in person. Therefore, the on-site team in Geneva and domestic team were divided. So the domestic team was continuously updating the data and information, and the on-site team, their roles are also divided. So such as preparing lobby papers and proposals for the concluding observation, also preparing press release and making some pickets, and we work in orderly manner. We've come all the way to Switzerland, so we try to bring back as many achievements as possible. In this regard, the concluding observation of Human Rights Committee as follows. They said the committee also concerned the reports of heavy-handed policing of protests by disability rights activities in the South Away, including use of excessive force to block and remove protesters, and application of criminal law to arrest, investigate, and fine protest organizers and participants. These are fruits of our efforts include even one more term such as persons with disability and disability rights in the concluding observation. However, Korean persons with disability are still holding rallies and demonstrating to ensure their right to movement. And the police are suppressing them with excessive force, while the prosecution is prosecuting a large number of disability activists. Most of the prosecuted charges are based on activists getting off the subway or just stopping for a moment during the rallies. These actions are generally considered to be peaceful rallies, and peaceful rallies are constitutionally protected. With according the General Comment number 37 of the Human Rights Committee, we emphasize acts that simply interrupt the flow of traffic or cause inconvenience to daily activities are not considered violence, and all rallies are bound to cause some inconvenience, which is a basic element that must be accepted in a democratic society. It is difficult for a small number of people to handle dozens of cases. Therefore, we will conduct some research to publish a manual that can be directly applied to the practice. So we hope more lawyers can participate. And finally, I would like to share my concerns related to the rights of children with disability, especially their rights to education. In Korea Act on Welfare of Persons with Disability and Special Education Act still have medical perspective on disability. If a disability is seen as a disease and cannot be proven with a doctor's certificate, it is not recognized as a disability. But the Anti-Discrimination Act stipulates that the necessary equipment, facilities, and support personnel be provided to children with disabilities so they can receive education. Since the Anti-Discrimination Act is not based on medical perspective, children with disability can be guaranteed their rights under this act even if they are not registered. However, the problem is education rights of children with disabilities are being violated because national policies and strategies are not harmonized with the CRPD and other human rights treaties. It is necessary to respond to such violation of rights through lawsuit or petitions, but in fact, many children with disability and their parents are not aware of their rights. That is why my colleague and I conduct a pilot Rights of Student with Disability Education program in March. I have one dream that I have had since I majored in education in college. It is a world where children can dream of their own dreams and have opportunity to achieve them. Regardless of disability, gender, race, or social status. I know that it's difficult to realize such a world, but I hope that small efforts and fruits will come together to make the world a better place. Thank you very much.
Thank you very much. We're going to turn it over to Mayuko's presentation now and then take questions after Mayuko's presentation.
Hello, everyone. My name is Mayuko, and today I'll be talking about how people under guardianship in Japan won the right to vote. And this is the title of my presentation. So first, to give some background on the case that I'm looking at today. So on February 1st, 2011, a Japanese woman with Down syndrome filed a lawsuit at the Tokyo District Court. And the purpose of this lawsuit was essentially to challenge the constitutionality of a particular provision that had existed within the Japanese election law at the time. And this provision had stated that people who were placed under guardianship, or what is called adult guardianship in Japan, were not allowed to vote in elections. And so this woman, whom I will call NT by her initials, she had been voting all her life ever since she became an adult, all the way up until 2007 when she was 47 years old and she had been placed under guardianship. And the reason she had been placed under guardianship was essentially because she just wasn't really good at managing her finances and her property. And so her father, in an effort to protect her property and, prevent her from becoming a victim of fraud, he decided to place her under guardianship, under his guardianship. But as soon as NT was placed under guardianship, she found out that she could no longer vote in elections. And this really upset her because, as I mentioned before, she was super politically involved all her life. She had been voting in every election. And so with the help of her father and also a team of disability rights activists, she decided to file a lawsuit at the Tokyo District Court. And As soon after NT filed this lawsuit, 3 other similar lawsuits also popped up in different parts of Japan, Sapporo, Saitama, and Kyoto, all challenging the constitutionality of this voting restriction, and all led by plaintiffs who were under guardianship. And then 2 years later, in 2013, the Tokyo District Court ruled in favor of the plaintiff, NT, arguing that the voting restriction in the election law was indeed unconstitutional. And then a mere 2 months after this court decision, the National Diet, which is Japan's legislature, they passed a bill to completely repeal this disenfranchising provision. And as a result, newly enfranchised around 136,000 people who were under guardianship at the time. So the main question is, what explains this success? How did NT and her supporters succeed in getting this disenfranchising provision repealed from the election law? And to answer this question, I'll be focusing on 2 major factors that I believe were particularly important to the success of the suffrage campaign. And by suffrage campaign, I mean the lawsuits and also the lobbying that took place after that lawsuit in order to get the election law repealed. So beginning with the first factor, I'll be focusing on, so I call this centering. Essentially, by centering, I refer to how the suffrage campaign, the lawsuits, and the lobbying were carried out in a way that highlighted the self-advocacy and the agency of the individuals who were directly affected by the voting restriction. Generally, individuals with intellectual or mental disabilities, or the shogai Tōjisha in Japanese. These individuals, like NT and the other plaintiffs from the 3 other court cases, were given the opportunity to actively and publicly participate in the court proceedings, as well as the awareness raising campaigns that were conducted alongside the lawsuits, and also to meet with some lawmakers after the lawsuit. And thus they were given the opportunity to directly convey their concerns to the judges, to lawmakers, and to the media, instead of being sidelined and excluded from this campaign, which often ends up happening when it comes to people with intellectual or cognitive disabilities. The reason why I particularly focus on this centering aspect as one of the key factors is because, number one, centering helped garner public interest in the voting restriction issue by putting a human face to what was at the time a relatively niche legal issue. Not many law scholars were debating whether or not this restriction against people under guardianship was, justifiable or not. And it wasn't a very well-known issue either among the general public. And additionally, by centering the individuals who were actually disenfranchised, and showing to the world that they are actually capable of publicly advocating for their own rights, this effectively challenged some of the social assumptions and stereotypes that also surrounded people under guardianship that had long propped up the voting restriction in the first place. And so to give some specific examples of this, what I call the centering process, for example, I had a chance to speak with the head lawyer who represented NT in the Tokyo District Court case. And in her words, one of the key factors that likely influenced the court's decision was the fact that NT, the plaintiff, was physically present in every or almost every court session, and how she had given her oral statements to the judges in person. And so this may have worked to personalize and concretize the voting rights issue by showing to the judges that an actual person who was standing in front of them had been deprived of her right to vote. Additionally, during the court proceedings, the lawyers also screened a DVD that they had created with the help of some volunteers to show just the everyday personal life of NT and the other plaintiffs. NT really liked to knit and create some crafts, for example, just their daily routines, to further emphasize that these plaintiffs were in fact, normal people who led normal lives just like everyone else. And perhaps as a result of these efforts, after issuing the decision in favor of the plaintiff, the chief judge of the Tokyo District Court even directly spoke to the plaintiff, essentially giving her encouraging words to, please, vote with your head held high and to live a good life, or something along those lines. So this signifies how the judge had essentially come to see NT as an actual individual instead of an abstract plaintiff. Additionally, NT and the other plaintiffs also actively participated in public information sessions that were held to raise awareness about the court case, which was organized by some lawyers and volunteers from local parents organizations. The DVD that I just mentioned before, that was also screened at these awareness-raising campaigns. NT and her father also participated in a press conference after the court case the court issued its decision, and their faces and their statements were also publicly published on national newspapers. And then after the court case, NT, her father, and her lawyers met with members of the Komeito Party, which is the coalition partner of the ruling Liberal Democratic Party of Japan. And when they met, the members of the Komeito Party personally apologized to NT, saying that, quote, they had no idea that they were disenfranchising such capable individuals as her, and that they were sorry for their lack of awareness, and that they would, make sure to restore voting rights to people with people under guardianship. And then afterwards, Komeito and LDP established a project team for drafting a bill to revise the election law. And ultimately, the law revision itself was passed as a joint effort of lawmakers from multiple parties, not just Komeito and LDP, but from opposition parties as well, the Democratic Party of Japan and others. This just goes to show how the issue had succeeded in garnering kind of broad, nonpartisan support by the end. And yeah, that was just some of the examples that I had for the important role that centering the individuals had played in the suffrage campaign. And then another second factor that I argue had made the suffrage campaign so effective was also how the activists, and particularly the lawyers representing NT, had frequently referenced international trends and developing norms regarding the political rights of people with intellectual or mental disabilities that were starting to gain traction around the world. So at the international level, voting restrictions on the basis of guardianship or mental incapacity or legal incapacity in general were starting to be seen gradually as human rights violations, especially since the latter half of the 2000s with the adoption of the UNCRPD, and also since, particularly since 2010, when the European Court of Human Rights ruled in a landmark case titled Kiss v. Hungary that automatically disenfranchising all people under guardianship violated the European Convention on Human Rights. And so as a result, many, or at least an increasing number of countries were starting to lift or gradually revise their voting restrictions that targeted people with intellectual or mental disabilities. And so the Japanese activists, particularly the lawyers, constantly referenced these global developments during the lawsuits and the lobbying processes. And these references were helpful in convincing judges and lawmakers that this wasn't just a domestic legal issue, but increasingly a universal human rights concern, and an issue that was increasingly receiving international scrutiny. And additionally, by providing specific examples of how other countries have changed their laws to expand suffrage, lawyers were able to provide judges and lawmakers with concrete models for law reform. So, for example, in the complaint document that the plaintiff side first submitted to the Tokyo District Court, they argued that the voting restriction not only violated the Japanese constitution, but also violated international human rights law like Article 29 of the CRPD, which talks about the political rights of people with disabilities, as well as Article 25 of the International Covenant on Civil and Political Rights, which guarantees political rights for all citizens. Additionally, they also referenced specific countries like Germany, UK, France, Hungary, and some states within the US that have revised voting restrictions against people under guardianship over the years. And according to one of the lawyers whom I had interviewed, the chief judge of the Tokyo District Court seemed to be particularly interested in hearing about these foreign cases because they provided a roadmap for changing the Japanese election law. And so throughout the court case, the lawyers kept submitting additional pieces of international evidence to back up their case, like academic articles and reports on voting rights developments in other countries. And they even submitted a copy of the European Court of Human Rights decision that I just mentioned earlier. And likely as a result of these efforts, the Tokyo District Court decision that was finally issued in 2013 also emphasized these international norms or trends, and specifically referenced examples of countries that had already revised their laws, like UK, Canada, France, Austria, and so on. And the decision also mentioned how the Japanese government was at the time preparing to ratify the CRPD, and therefore should revise the voting restriction in light of this as well. And so the lawyers' references to international developments clearly influenced the final court decision. And then after the lawsuit, the lawyers also often stayed up late into the night, similar to what Ms. Lee was talking about before, essentially faxing various lawmakers to provide them with information about foreign cases as model cases for revising the Japanese election law. And in order to also get them to bring up these cases during national diet debates surrounding the law reform. The lawyers also invited a law professor who was knowledgeable about foreign voting rights laws into one of the LDP Komeito project team sessions in order to lecture the lawmakers about foreign cases. And they even faxed articles and reports that had been published by organizations like Human Rights Watch and Inclusion International about the Tokyo District Court decision in order to show the lawmakers that there was international attention on this issue. So these are just some of the examples of how activists frequently referenced international trends and developments as a way to both provide information about foreign cases as models for law reform, and also as a way to imbue a sense of urgency into this issue by framing the voting restriction as a human rights issue that was increasingly being scrutinized internationally. Yeah, just to summarize, in this talk, I focused on these two factors of centering the Shogai Tōjisha, the individuals who were directly affected by the voting restriction, and also referencing international trends and developments. Of course, I don't necessarily claim that these two factors are the only things that helped the suffrage campaign succeed. For example, another important factor was the presence and the support of a national network of local parents organizations called Ikusekai, and also other disability rights organizations that had supported the campaign by, for example, filling up the courtrooms, distributing a nationwide petition, and helping to organize awareness-raising information sessions, all of which also definitely helped the campaign as well. And finally, I'll also end by saying that the repeal of the voting restriction in 2013 wasn't just the end, in the sense that it also became a starting point for some new discussions about how to make elections actually accessible for these newly enfranchised groups of people, voters on the ground in Japan. And so in recent years, a few cities like Komae City and Tokyo have been actively working to make elections more accessible by creating easy-to-read voting manuals for first-time voters with intellectual disabilities, educating voters about their rights at the polls, encouraging candidates to create easy-to-read campaign materials, training election staff in how to properly communicate with people with intellectual disabilities, and so on. And of course, these efforts are ongoing, and not all or even most municipalities are actually pursuing such proactive measures. So I just wanted to highlight this at the very end, that there are still many practical accessibility barriers in the Japanese electoral process that should be addressed. But yeah, on that note, thank you for your time.
So thank you very much to both Ms. Lee and Ms. Maeda. I can call you Mayuko maybe, for your presentations. I think they gave us really great examples, concrete examples of how rights are being developed and deepened in Japan and Korea. So I would like, as the moderator of this panel, to maybe start out by asking you to just talk a little bit more in detail about what some of the pros and cons of using lawsuits as a tactic are. Were there debates among the disabled persons organizations and the families about whether we should use lawsuits, or were there other better tactics for raising awareness about the problems? Sometimes in lawsuits, there can be an imbalance between lawyers and the Tōjisha or the 당사자, the people with disabilities, the affected parties. So how did you navigate the difference of expertise or knowledge about the legal process between lawyers and disabled persons. And in those debates, what were some of the pros and the cons, the good sides and the bad sides of using litigation as a tactic?
I think in terms of the pros and cons and whether there were debates about this among people who were involved, I don't think among, for example, the parents' associations or the people who were affected by the voting restriction, there weren't any, as far as I could identify, discussions about the cons of lawsuits. I do think that it was just seen as very difficult to achieve in the sense that first you had to find a plaintiff who was willing to, participate in such a lawsuit, potentially even revealing their identity and the fact that they were under guardianship, which is in some cases stigmatized in Japan because it's associated with intellectual disabilities, cognitive disabilities. So I think the reason why a lawsuit didn't take place until 2013, despite the fact that the voting restriction had been there for a long time, was simply because it was hard to find that person that was willing to become a plaintiff. I think a definite pro of a lawsuit is that it kind of rallied people. Like before the Tokyo District Court case, this voting restriction issue in Japan wasn't really talked about at all. It wasn't really a point of debate. But as soon as the first lawsuit was initiated, suddenly 3 other lawsuits also popped up in Japan, which showed that the importance of a first mover and how, having this person who symbolized the victim come forward publicly and file this lawsuit, it kind of rallied other people who were affected by the voting restriction, but weren't, for example, maybe courageous enough to come forward, or they didn't know that they saw that a person was willing to undertake this legal endeavor, and so maybe they were also encouraged to enter into a lawsuit or support the campaign in some way. So I think a lawsuit can help rally people around the issue. But I think, yeah, I'll just end here.
I think the pros of the lawsuit is quite maybe last chance to ensure the rights of persons with a disability, because in the first case I shared you, the persons with disabilities, they campaign and they met the government people and also lawmaker peoples, but they tend to hear their voices, but there are no changes at all. So that is because after maybe 9 years after they start, after that we file a lawsuit, but we are in the process of the lawsuit, so I'm not sure the result of these cases. And also I think that the problem especially in Korea, we claim that it is the public interest cases. If we fail at the time, we ask for government to not to pay the fare or the money, because that is the barrier when the persons with disabilities file a lawsuit, because it is very difficult to win in the lawsuit, and also it takes too long. For example, when I was in intern in law school, at the time we are make a lawsuit for people, blind people, to take some roller coasters in amusement park, but it takes almost 10 years just for some right to some fun or right to some leisure, but it is too too wrong, and there are many issues because it is about money and some safety, because the amusement park said it is danger because we are not allowed the blind people to take the cars and roller coasters like that. But in that case, the first trial we failed, and second was successfully win, but it also go to the Supreme Court, so it takes 10 years, more than 10 years. And also in case of some right to education, some parents they are too it is difficult to they have to grow their children and take care of lots of things for their children, so there are no time and no money or no lots other things to some make a lawsuit or just raise a problem. So I think we have to make them know what is their rights, and there is a way to be good like that. So, but there are lots of problems.
Thank you very much. Yeah, I think you raise a lot of important points about the duration, the cost in time and money, especially if you lose a lawsuit. But Mayuko, you emphasized the informational impact of lawsuits in terms of raising awareness, not just in the participants in the courtroom, but beyond, to attract media attention.
Hello, my name is Benny. I'm an undergraduate student at the Elliott School of International Affairs. I have a question for Ms. Lee specifically. It's not explicitly about the lawsuits, but how do you think public opinion swayed disability rights improvement in South Korean politics and lawmaking? I'm specifically referring to the right to movement protest in Seoul subways. I recall a poll from KBS in 2023 that over 50% of survey citizens understood the reason behind the protest, but over 50% of survey citizens also said the protest methods were inappropriate. As a result, I saw that about 40% of the surveyed citizens said due to the subway protests, their views on disability rights tilted negatively. So just wanted to see how public opinion would influence some progressions on democracy and disability rights making in South Korea. Thank you.
Thank you for asking and raise the issues, because it is very important issues in Korea. And actually, my families or other friends, they ask me why they do that like that, because they wait for their work. Because in Korea, in Seoul, there are lots of people use subway than the buses. But at that time, I said these rallies began almost 20 or 30 years ago, but they didn't know before. But just now, even it is very some kind of violence and some very radical movement. At that time, people and other lawmakers and some politicians and other people know there is a problem. So I know there are lots of people don't like it, but I think it is because of that, it is important, because they don't know their voices at all, because their movement is just more than 20 years, but just now they know. So when my friends ask about me, because of you know the problem, that's why they do the release. So thank you.
Thank you very much. Yeah, for those of you who experienced the mobility rights protests in Seoul subways, there was a lot of public attention to them, in part because people felt that their commutes to work were being delayed. And I think the Seoul Metro, as well as the Seoul mayor, filed a lawsuit. So this is maybe a con of lawsuits against the leader of the mobility rights protest, in addition to the arrest that you mentioned. So I'm going to turn now to our questions online. We have one from Hezi Smith at the Harvard Program on Disability. And he asks, thank you for your presentations. I have a question for Mayuko. You mentioned one factor in the campaign's success was the lawyers' reference to international legal norms. Did the lawyers and or the organizers also look to other successful political participation, litigation, or campaigns from abroad? Not just the legal changes abroad, but other activism abroad? Not so much from the legal perspective, but from the organizing perspective. And he would be interested to know if lawyers and organizers were also paying attention to campaigns across borders, not just court decisions. Also, were the lawyers and organizers subsequently supported or engaged in similar efforts in other countries? Have they taken their experiences and exported them potentially to the region?
Regarding the first point about whether they looked at other foreign suffrage campaigns from an organizational standpoint, I'm trying to think. I'm not sure. They may have, but I can't recall if, for example, the lawyers that I spoke with mentioned looking at how suffrage activists in other countries have conducted their campaigns in order to expand suffrage in their own countries for their organization. But I won't be surprised if they did. I'm sorry. And then the other question was looking at whether Japanese activists also try to, I guess, export their or try to achieve suffrage expansion beyond Japan as well. I think they have the lawyers that I spoke to have a lot of cases to deal with, not just voting rights. And so I don't think that they were actively involved in organizing for suffrage expansion in other countries necessarily, but I do think that they have participated in just generally, for example, CRPD related campaigns, advocating for example, legal capacity issues, or I think they also often communicated with NGOs abroad, but I'm not aware of specific activities that they did to help other countries expand suffrage. They may have, but again, I might not be.
Ms. Lee, you also mentioned the question of voting rights in your presentation. Were there examples of lawyers or activists learning from movements outside Korea? And what did they learn? And also, did they teach movements outside Korea about how to expand voting rights?
So a long time we have worked for the voting rights, but when I listen Maeda's presentation in Korean courts and other lawmakers, they don't put the importance. They don't think the human rights treaty bodies of treaties or CRPD is important because they don't use the CRPD as the basis of judgment or decision, but we keep claiming that it is the same as the role in Korea, but I'm not sure we are doing a lot, but it's not some level to share to our works to other countries.
Yeah, this is an important point, I think, that you raised also with education rights. On the one hand, raising public awareness about rights and thinking in rights terms is a challenge, but also raising awareness among judges and politicians that both the Korean and the Japanese constitutions treat international treaties and domestic law as law. But they don't often in court cases treat them equally or refer back to the CRPD. So that's another form of education that lawyers and activists can play for judges and lawmakers.
Good morning. My name is Richard Haddock. I'm Assistant Director for the Seeger Center for Asian Studies. I wanted to ask a question actually inspired by Mayuko's presentation about, you noted that there are different countries that were used for comparison and also some US states. And it made me wonder if the panelists saw significant differences between national level or subnational level movements or CRP campaigns. Do you find that there's greater successes or different issues that are talked about at a local, city, state, or provincial level versus national? Thank you.
I can share Korean case. Sometimes some very local laws or regulation is much better than the law, because in case of some students' rights, some big cities or metropolitan cities, they, for example, Seoul, they expel the regulation of student rights of student, but some other small cities, they still have that kind of much better regulations. And I think it is depend on people. Oh, so when the politicians, so that is why the election is important. But anyway, I think even if there is a good human rights treaties and other good laws, but even if the politicians or lawmakers or judges are not use it, they're useless, I think.
I'm not a huge expert on subnational versus national level comparison of advocacy efforts with regard to the CRPD in Japan. But one example that might be slightly relevant is, so I kind of mentioned this in my presentation too, but after the 2013 election law repeal, so I talked with a vice mayor of one particular city in Tokyo, and when that election law was repealed so that all people under guardianship were newly enfranchised to vote, he noted that, okay, well, the law was changed, but how are we actually going to implement it? And so he was one of the first kind of people at the municipal level in Tokyo to really start these proactive measures to make elections actually accessible for people with intellectual disabilities. For example, like I mentioned before, creating easy to read voting manuals and encouraging candidates to make accessible campaign materials. So I think that's one example of how maybe advocacy at the national level worked, but then the gaps that were left behind were then filled in by some handful of municipalities like the one that I just mentioned.
Thank you very much. We have a question from online that I'm going to modify slightly because it relates to Benny's earlier question. This comes from Jonghyun Nam, who's a PhD candidate in sociology here in the DC area. She wants to know if you've thought through how activism affects public perceptions of disabilities. And if I might add a question to Ms. Lee, you mentioned that you had a pilot program in terms of raising awareness about education rights recently. So if you could share a little bit more of your on-the-ground experience in Korea, for example, when I think it was 2017, when they tried to build a school for people with disabilities, there was a lot of protest by the local people who owned apartments in the area, saying that their house prices would decline if there was a school for people with disabilities in the neighborhood. So in what ways can activism appeal to receive support from bystanders, nearby neighbors? And in what ways does activism sometimes create a backlash? Or what are the best ways for activists to help raise awareness in a positive way for public perceptions of disabilities?
It is very difficult question because I'm not sure what I'm doing is affect other publics in perspective because I think normally the public they don't have interest in disability rights, but even there is a news about some release in station, subway station like that at that time. It is sad, but in Korea, they it's normal. Other people usually says think that the persons with disability always nagging or some asking for something, but at that time in this moment when I go to some education for awareness raising, at that time I talk about some other non-disability people that it is the based on rights because that is the rights means when they born in Korea they naturally they got the rights and it it is not depend on they are disability persons with disability or not, but I think in general the education about rights should be mm, well organized or and spread out to whole the nationwide because I'm not sure some people try to they are different from me and that is not my business, the kind of things, so I try to break that kind of perception, but it is quite difficult. I'm not sure I'm successfully doing that kind of things.
Again, this is just going to refer back to the specific case that I talked about today, but I don't really have like public opinion data on people's like how they perceived the lawsuit in Japan. So I'm not sure if it was reported in the national newspapers, the Tokyo District Court decision, and most of the newspaper coverage, in fact, that I've seen, all of them were very positive. And so I think in this particular case, at least, especially since the plaintiff NT was just instead of being hidden from sight, she was just put in the spotlight, and they just honestly showed how capable she was and how she just really wanted to vote. I think that kind of affected public views, or hopefully affected public views of people under guardianship in a positive light, essentially eliminating stereotypes surrounding them that they're all just incapable of everything. Like that's just not true. It's just primarily for financial management or property management. At least in Japan, that's what guardianship is for. So I think for this case, it hopefully affected public perceptions in a positive.
I'd like to thank our speakers today. It was a fascinating discussion in which I think we can continue in the next panel and the one after that. So please join me in thanking our speakers.
Now my pleasure to introduce our next two speakers. First, we have Henghao Chang, a professor in the Department of Sociology, who currently serves as the Dean of the College of Social Sciences at National Taipei University, Taiwan. He earned his PhD in sociology from the University of Hawaii at Manoa and is the founding president of the Taiwan Society for Disability Studies. His research focuses on the disability rights movements, representations of disability, and inclusive education. He serves on the editorial board of the International Journal of Disability and Social Justice and guest edits the special issue Disability in East Asia. His work has been published in Disability and Society, Review of Disability Studies, and International Journal, Taiwanese Sociology, and Taiwanese Journal of Sociology. He co-edited a book, Disability Studies, Theories and Policy Implication, which introduces disability studies to the Chinese language. Our second speaker is Reiko Nishida, who earned her PhD in law from the University of Tsukuba, Japan. Currently, she's a junior researcher at the Institute of Comparative Law at Waseda University, supported by a Japan Society for the Promotion of Science grant for years 2023 to 2025. Her research focuses on comparative equality and anti-discrimination, including affirmative action to promote equal employment opportunities for individuals with disabilities, women, and foreign workers. She has expertise in anti-discrimination laws in both the US and Japan. She is currently a visiting scholar at the Seeger Center for Asian Studies, Elliott School of International Affairs, George Washington University, where she continues her research.
Hello, my name is Heng Hao. Glad to be here, and I'm sociology by training. So naturally, I'm questioning about like top-down approach by legal scholars. And so today I'm going to present like civil society's response to CRPDs. So, and it's in a way, we try to present different versions of how DPO's approach to CRPD and how the society responds to the individual rights-based CRPD approach. Okay, well, I think I added a special issue on disability in East Asia. I admit I don't know enough about East Asia regions. It's too big and too comprehensive. So I know the most is Taiwan. And so today I'll talk shortly about the basic context in Taiwan and then present my case, the contradictory role of family. So we are using three cases, like moving out from home, dual aging family group home, and symbiotic homeland, to showcase how different DPOs approach to the institutionalizations and community livings. So in the literature, there are a lot of discussion about or debates or criticize the individualism or individual rights-based approach to CRPDs. Especially we talk about or communal society or mutual support or family in Asia. And some discussion bring about Asian value, but I think that kind of discussion has been old, right? The reason discussion, part of the argument goes to region types. So like some research on China and Singapore talk about you cannot use human rights approach, but you can use different approach to promote CRPD. You don't use the word of human rights or rights model, but you can still talk about an advancement of society to promote like social developments or social inclusions. But in democratic society, it is different. We can use the right word of human rights. So I think Professor Harrington's argument talking about democracy and the legal political opportunities emerging in South Korea and Japan. And it's certainly similar in Taiwan, that democratization brings different opportunities to make legal mobilization possible. But what I try to present today is well, region types, we can talk about two types. One is democracy, right? The other is actually welfare states. So some discussion in East Asia is about so-called familistic welfare states, which means like you rely on the family to provide the basic social support. You did not go through that like a Nordic welfare style or even social insurance style. So it's pretty much rely on the family. And in a way, it's still like that. The whole state structure looks like this. So my basic question is like, can CRPD change the whole feministic welfare state thinking or the redistribution of the wealth, the resources? Well, I don't have a clear answer. So this is what I try to say. How have the government and civil society's response to CRPD implementation, and how does localization of UN CRPD reflect tensions between the individual rights paradigms and Taiwan's family and community-oriented traditions? And just make it briefly, there are disability legislation before CRPD. So you have like Handicap Act and the Person with Disability Protection Act and People with Disability Rights Protection Act. And then this is something I need to mention, that although Taiwan so-called ratified CRPD, but we don't really have the right to ratify CRPD. Taiwan is not part of UN, right? So I always feel like it's very contradictory that CRPD is all about inclusion, but we're not included. But still, Taiwan have like localized way to implement CRPD. We formed the international expert committee and to invite them to come to Taiwan to do like 4 days reviews. So in a way, they can meet government officials and meet civil society groups and DPOs in person in Taiwan. So you won't spend a lot of money to send people to Geneva or to New York, right? And in a way, it's trigger more participation from the government body and also the DPOs. So some people, some of my international expert friends say it's even a better model than the US CRPD model. But anyway, this is not UN models, but that's what's going on in Taiwan, and Taiwan goes through 2 times review already. Yeah, and there are DPOs and disability organizations before CRPDs. So we have like Liu Xiaohui is a well-known disabled writers promote like disability rights, like employment quota, political participation, and discrimination and accessibility. So since that only happens after CRPD, there are other organizations that actually work on disability rights issues. And also parents has early involvement in Not in My Backyard movements. So actually in 80s, when the NGO start to have the first training program for a person with intellectual disability, there are strong community resistance. So they started like petitions and then go for the president. But so they're still under martial law. So like 500 parents get together, have the petition say we need a community facility for our children. Is something big in that time. So, but because of that petition, that they have the revised Special Education Act, so started the principle of zero rejections. So before that, the school can basically exclude students with disabilities. So this is something I need to mention that this is the historical background. So since 2000s, there are new generation of DPOs start to talk about self-advocacy. They are talking more about disability rights and human rights models. So we even have like hand angels who provide sex service for disabled persons. And after CRP, there are more DPOs. I can only name a few. But something worth mentioning is that you start to have human rights groups actively work with DPOs. Campaign Watch start to coordinate local civil society groups and DPOs for panel reviews. So I think that's important that before that, legal scholars did not really work close with DPOs and NGOs. But starting from the UNCRPD and Campaign Watch start to bring courting lawyers to work with DPOs and use lawsuit and legal mobilization as a means to achieve disability rights. And also the government response, one is like Taiwan have the National Human Rights Mechanism, and also the government has a budget for legal aid for disabled persons. So if you are qualified disabled person, well, qualify, you can apply for legal aid for lawsuit. And you also have an amendment of the law, revised Special Education Act. Another thing is the revision of People with Disability Rights Protection Act. It's ongoing because they are actually stuck on the community living issues. So here's the main body of my presentation, reconsidering family in the Taiwanese disability rights discourse. So actually, Taiwan Civil Code still places responsibility for the care of people with disability, both children and adults, on linear family members, parents, siblings, children. So if you abandon your disabled children or siblings, you'll be fine, supposedly. Yeah. So that's the basic of so-called familistic welfare states, right? They don't treat adults with disability as individual. They are essential part of the family. Family should be responsible. So according to the survey, 82% of disabled people still living with their family. So when we look at the disability rights movement in especially the new generation, New Mentality Independent Living Movement Association, the first move they try to do is encourage disabled person to move out from the family home or move out from institutions, like declare independence. So I think the picture I show is that it's a Dr. Sun. Dr. Sun is a PhD in math. He got a PhD from UT Austin. And actually, throughout his career, or student career, his family, his mom actually support him to go through the PhD programs. So after he returned to Taiwan, he worked with the independent living movements. He said, no, now I got a postdoc, I got the salary, I want to be independent. So that's what I do, like move out from the family and show the society like we can live independently. But the societal response is not very strong because the idea is still new, and what kind of support they need, or like the host personal assistant or community living support are not in place. So it's like 10 years ago, but now since they encourage more people to live in the community by themselves, there's a historical victory 2 years ago by Yujie. That's the lawsuit against the government for personal assistance. And what Yujie says is just, I just want to soak in the urines at night. Because Yujie is 65 years old. He lives alone with low income and with severe disability, suffering from muscular atrophy, and no strength in her body and can hardly move any part of her body. She was placed in the institution before, but she decided to move out, live by herself. And he relied entirely on others for basic needs, such as eating, using the toilet, and turning over in bed. So the new Taipei City government actually provides some home care and personal assistance, but the limit of support was only 60 hours. So in 2020s, he applied for like full support for 24 hours, but he got rejected. So the Legal Aid Foundation helped her to file the administrative lawsuit. And after 2 years, there's a court ruling that, well, the restriction of 60 hours is questionable. So they're not saying you have to provide 24 hours per day, but it's that you need to provide reasonable explanation how much hours you can provide. So they start to add like 100 hours for her, and then another 248 hours. But the difficulty is that even they add hours, they cannot find support person because the whole personal assistant system and personnel and training and the service provider are not very strong. So that becomes the case and still ongoing. And this is a historic victory, but then there are several ongoing lawsuits against the government say you cannot put a limit on my application for the personal assistance. And then it's actually directly challenge the feministic welfare state because the assumption of the government is that the family have to take care of their disabled members. So the whole personal assistant system or the long-term care rely on the family. So there's a revision of the amendment on the disability law, but it just stuck there because it started to draft the revision in 2022. But the DPO say, no, you did not promote community living. But the government simply say we did not sufficient funding to do that. And then this is one case that pretty much what you can vision like how CRPD affect DPOs use the legal means to achieve their goal. But the other two cases are very different. That another argument is like Taiwanese have these institutionalizations. But if you look at the statistics, institutionalization is not a big issue in Taiwan because most people actually live with their families. And so when some scholars and DPOs talk about decentralization, actually make a lot of parents' organizations angry. That it's an Asian family, we have a disabled person that has never been trained to live in a community. There's no community support. So where does our kids goes if you want to close down all the institutions. So now you have see two kinds of interesting institution. This is like a so-called alternative community care models. It's actually a social housing project, but they build small buildings for disabled persons. So in any Western standards, this is not institutions; it's still institutions. But in Taiwan's cases, that the small house, the small apartment in the middle is surrounded by the big social housing project. But because you're not in my backyard movements, they cannot place the disabled person in. It's hard, very difficult to place disabled person in community housing. So that's kind of compromised way they make it happen. And it's actually become ideal model for a lot of parents organizations. What's more interesting is this. It's hard to translate. I use like dual agent family group home, but it's not really group home. It's like social housing projects. And retired elderly parents, they have a dual agent family organizations. They bring their disabled children, like normally at 40 or 60 years old, and move to the community, the social housing, as a mutual help groups. So like there are 8 or 10 family, adults with intellectual disability, mostly autism, living with their retired parents. Some of them reach 80s, and they share the social housing project. And they have some kind of community support in the social housing projects. And actually, many parents receive long-term care workers training. So they can actually care for each other's children and get support from the governments. They cannot take care of their own children. So that's how they do this kind of mutual support in a social housing project. And when we do the interview, they will say, we'll expect this kind of mutual support from other family. After I pass away, they will support my children. Yeah, that's their wish. So, and they can see that kind of cultural family obligations is there, that they cannot see the feasible of community living, that they believe it's very difficult for their children, like over 40 or 50 years old, can live independently. They use this kind of mutual help group to support each other. But the future is questionable. I think it's easy to see, right? But there are several groups trying to replicate the same practice, building on more dual agent family or group home. And the third case is even more interesting. They don't use any legal language on CRPD and human rights at all. It's self-help alternative family factory residence. It's called 新巨人, New Giant Well. It's actually a combination of new immigrants and wheelchair users. They're starting from homeless self-help groups. So they are actually living in the streets. A group of people, disabled people living in the streets, have no job. And their founder, who is a wheelchair users, kind of organize those people and become street vendors. So that's why you can say they sell, tissues and pencils and on the streets. And they become a group of 40 or 50 persons. So it's pretty much a self-help homeless wheelchair users group, and turn into a street vendors organizations. They founded in 2003, and in 2008 they actually rented tin roof buildings as their home for 40 or 50 persons. And unfortunately, it's on fire. So they were kicked out, and the city government say, no, you cannot have people live like these conditions. But they have no place to go. They turn into homeless again. So they rent another place, still not legally supported by the government in 2009. And it had been backforced by the government and the groups, because the government has no shelters or other living arrangement support for them. So by the end, I think with the support of the New Taipei City government, they find a factory dormitories like for them to rent. So they lease the new home in Tuzhen, which is next to my university. So, well, it's not next to, but very close to my university. So it's a factory place. So what they do, they call it themselves a symbiotic homeland. So they live in together as a family because they're all abandoned by their original family. And they support each other in doing their own business, but they have to contribute to the whole home to maintain the their symbiotic homeland. And now there's a 40 to 50% with disability there. And then they actually build a new business called food truck. And they call themselves like localized independent livings. They actually live independently and then not rely on government fundings. They actually don't like government fundings because there are so many regulations. They actually start to use some care support and personal assistance support in their like group homeland. Conclusion. I don't know how to conclude it. I think one thing we can see this kind of familistic state or feminism in law, in cultural practice, in social policy. So I think it's not only social policy because a lot of families still believe they have to hold their responsibilities for their children. That's why you see this kind of dual aging family home. And so when we look at localization in UNCRPD, you actually need to be more culturally sensitive. I'm not, in a way, it's not talking about Asian value. We cannot receive human rights models, but it's actually also about how the society support different persons, how the state capacity. I mean, it's possible. It's actually has been challenged, and there are more resources goes to community living these days. But still, you want to have a full community living support, there's still a long way to go. So I'm proposing maybe we need to have more social cultural sensitive approach to disability rights policies, or a more procedural approach rather than like use UNCRPD as a rigid standards everyone have to follow. Yeah, that's it. Thank you.
Morning, everyone, and thank you for coming to this event, and thank you, Celeste, for organizing this event, and thank you, Lisa, for kind introduction. So today I'd like to talk about Japan's employment system for people with disabilities, focusing on the quota system and its impact on the workforce. In Japan, both private and public sector employers are required to hire a certain percentage of people with disabilities. This is known as quota system. And so this chart illustrates the number of employees with disabilities working in private companies under the over years based on annual employer reports required under quota system. So this chart starts from fiscal year 2004 and showed a consistent increase in the number of employees with disabilities hired by private companies. This data only includes people with covered disabilities under the quota. So, which means most of them have a disability prospects. I will talk about the disability prospect system later. And also the quota system applies only to individuals with disabilities employed under a formal employment contract. So it does not, this chart, this first chart does not include people in welfare programs such as sheltered workshops, which are not contract-based. Oh, sorry. The key trend observed in this data is that while the employment of individuals with physical disabilities in the bottom white one has remained stable, the number of people with mental health issues has increasing. Another notable observation is that the number of employees with disabilities did not decline during the COVID-19 pandemic. So in Japan, legal restrictions on layoffs prevented a significant drop of employment during the pandemic. This second chart shows the percentage of each age group in the workforce for different disability categories based on the government survey conducted every 5 years. So unlike the quota-based reports, this data includes individuals with broader disabilities who do not have an official disability aspect. So the gray line represents Japan's overall workforce, the peaking at age 45, 49. The purple line represents workers with physical disabilities, showing an increase with age, and particularly with 17.4% of people with physical disabilities in age 65 and over. The light and the dark blue looks like black one represent workers with intellectual and developmental disabilities, peaking at age 20 to 24, very young, when many are hired right after graduating from special schools. So from this, two key points can be observed. Supporting older workers in their transition from employment to community life after retirement is crucial. Sheltered workshops originally designed to help people with disabilities enter the labor market, but they must adapt to support those leaving from the labor market. And providing career development opportunities for younger people, especially with intellectual or developmental disabilities, is essential for sustainable employment. Both companies and policymakers need to address this. A challenge, however, is that many of these individuals are hired as non-permanent employees, Hiseki employee. So Japan's labor market employment is a kind of divided into two main categories. One, seishain, and Japanese are permanent employees, represented in blue. Permanent employee enjoy lifetime employment and seniority-based wage increase. The Hiseki non-permanent employees represented in yellow. Non-permanent employees have limited opportunities for promotions. So traditionally, Japanese companies hired new college graduates, provided internal training, and guaranteed lifetime employment. Although layoffs are legally restricted for seishain permanent employees, companies use Hiseki to manage workforce flexibly as they can terminate these employees when their contract ends. So historically, the Hiseki track was mainly occupied by women, returning to work after raising children. Therefore, transitioning to a seishain track was never considered. Gender-based discrimination is now illegal, but still the Hiseki track continues to be seen as lower status. So this graph illustrates the trend in seishain and Hiseki employment structure. While the number of seishain employees has remained stable for over 20 years, the number of Hiseki employees has gradually increased. This structure has a significant impact on how people with disabilities are hired and retained. So now let's examine the impact. The orange represents percent of Sooyeon workers, and the blue one represents one of the Hiseki. This graph shows only workers with physical disabilities have a relatively higher chance of being hired as Sooyeon. In contrast, almost 80% of individuals with intellectual disabilities are hired as shiseki. As the data illustrates, most persons with disabilities are placed in non-permanent positions, which affect their wage and career growth. Even though the quota system mandates companies to hire a certain number of people with disabilities, employers still have discretion to decide what type of employment contract they offer. So, historical background. In 1960, Japan enacted the Employment Promotion of Persons with Disabilities Act, which introduced vocational rehabilitation and a quota mandate for people with disabilities. The background of this legislation was that many people became disabled due to World War II, workplace injuries, traffic accidents in the shadow of economic development. Additionally, in 1955, 5 years before the enactment, the International Labour Organization, ILO, adopted the Vocational Rehabilitation Disabled Recommendation, which influenced the enactment of this law. So in 1976, it became mandatory for private companies to hire people with physical disabilities. The quota system has gradually expanded to include a broader range of disabilities. So in 1998, it expanded to include individuals with intellectual disabilities. In 2018, it further extended to include the individuals with mental health issues. The quota system has been central to Japanese disability policies and played a key role in raising awareness and improving job opportunities for people with disabilities. However, finally, in 2013, Japan introduced anti-discrimination laws, including reasonable accommodation mandates. Since Japanese companies had already been making workplace adjustment for over 40 years under the quota system, these legal changes did not drastically change employment practices. However, the quota system faces challenges related to the equal treatment. So many companies create specialized jobs for people with disabilities, which often differ from the regular jobs. Anti-discrimination laws require employers to treat qualified individuals with disabilities equally based on their abilities and performance. However, when the original job functions are customized, it raises a question of how equal treatment under anti-discrimination law applies in Japan. So let's move to the talk about the quota system. So private companies in Japan legally required to fill at least 2.5% of their workforce, total workforce, with people with covered disabilities under the quota system. The statutory rate of the quota is reviewed every 5 years, and since 2018, when hiring with individuals with mental health issues became mandatory, the quota rate has been gradually increasing. As shown in this presentation, this slide, the statutory rate is set to rise from 2% to 2.7% in 2026. This means companies must continue hiring employees with disabilities and also retaining them to fulfill the obligation. So Japan uses the Pacific system to certify individuals with disabilities. And the public holders benefit transportation discounts, tax exemptions, welfare programs, and the quota system. While the Pacific system and the quota system are totally independent, the Pacific determines whether an individual is covered under the quota. To encourage companies to hire persons with disabilities, quota offered these incentives and enforcement measures. These measures were introduced in 1976 or earlier and have evolved over time. So levy and adjustment subsidies. The quota system has levy system to balance the economic burden between companies that hire persons with disabilities and those that do not. Companies with over 100 regular employees must pay a levy based on their shortage. And here is an example. But what I want to say is this levy is significantly lower than the annual cost of hiring even one employee at minimum wage, which may tempt companies to pay the levy instead of hiring. Nevertheless, paying the levy does not satisfy the company's legal obligation, and persistent non-compliance can result in administrative guidance and eventual reputational consequences. The quota system enforces compliance through mild measures relying on administrative guidance and public disclosure rather than the strict penalties. So companies with extremely low employment rates receive guidance from the Ministry of Health, Labor and Welfare. They must submit a 2-year hiring plan and demonstrate improvement. And if the companies still fail to comply after 2 years guidance, and the continued non-compliance result in public disclosure of the company name. So public disclosure serves as a social sanction. Reputational risk pressures companies to take disability employment seriously rather than enforcement. So Japan's quota system has a double count and half-count measures to account for the severity of disabilities and working hours. These adjustments encourage companies to hire individuals with severe disabilities. And also employees with disabilities for work between 20 and 30 hours per week are counted as half an employee under the quota. Because originally the quota system focused on full-time employment, but it was later adjusted to accommodate part-time workers, especially those with severe disabilities or mental health issues. Let's move to the summary of employers' challenges. Employers in Japan face several growing challenges in meeting the requirement of the quota system. These changes are shaped by raising statutory quota, changing workforce demographics, and diverse needs of employees with disabilities. So shown in the first chart, the statutory rate for persons with disabilities gradually increasing and requiring companies to hire more individuals. Employers need to plan carefully for future hiring and retention strategies to meet these legal obligations. And many employers with physical disabilities, especially those with severe disabilities, are reaching retirement age, and the people with severe physical disabilities, they are counted as 2 people. So replacing them means companies must hire twice as many new employees. And this is increasingly difficult as the growing proportion of candidates are people with mental health issues. So the number of individuals with mental health issues entering the labor market is increasing. These workers often prefer shorter working hours and may have less stable employment, making long-term retention more challenges. And also more individuals with severe disabilities, including those who need 24 hours personal assistance, are seeking employment. So employers are expected to provide reasonable accommodations, such as assigning personal assistance. However, these accommodations can create significant financial and logistical burdens. This is the final slide, so I need to wrap up. The Disability Employment Committee in Japan is currently discussing several key issues regarding the future structure. So this is an ongoing debate over how covered disabilities should be defined or identified under the quota system. A key issue is whether to expand coverage to include conditions like chronic diseases, which are currently excluded. Expanding the scope could increase the number of eligible individuals, potentially promoting employment opportunities for people in the gray area who may not qualify under the current definition but still face barriers to work. However, this raises concerns about fairness and consistency in practice, as chronic conditions conditions vary greatly in severity. Some argue the quota system should maintain a narrow focus as the affirmative action measure, targeting those with the most significant challenges in securing employment. And many companies that hired people with severe physical disabilities are now facing the challenges of mass retirement. So replacing these employees with disabilities with mental health issues would require hiring twice as many workers to meet the quota. So some employers are demanding for a double counting system for employees with mental health issues too, to address this issue, but defining what constitutes a severe remains difficult. And also, if employees with the mental health issues are allowed to be double counted in the quota system, it would eventually reduce the actual number of available positions. This could undermine the overall goal of the quota system, which is to increase employment opportunities for all people with disabilities. So Japan's quota system has helped expand employment opportunities for people with disabilities, but shifting workforce demographics have exposed its limitations. After relying heavily on this strategy for years, it is time to recognize that the quota alone are not enough. So through inclusivity and quality employment, new and more diverse approaches are needed. Thank you so much. I will conclude my talk.
So thank you very much to both of our speakers. I think you provided some fascinating examples about the challenges of implementing policies regarding working, but also some creative solutions to these challenges in terms of living and working for people with disabilities. In the time remaining, we have a couple of questions online, but I also want to recognize any questions from our audience.
Thank you. I'm Kaya Chu. I am an associate professor in spatial education from the National Taiwan Normal University. I'm currently visiting George Mason as a Fulbright scholar. My question, I kind of want to touch upon the Asian family values. Professor Chung was talking about, of course, Nishita-san, if you could talk about what you think families' involvement are when seeking employment, that would be fascinating as well. But a lot of time, and law amendment and just establishment, a lot of times we see parents advocating on behalf of the children, especially those with more significant intellectual disabilities. So you will have family members seeking guardianship rather than supported decision making. There will be parents they want shoulder workshop rather than competitive employment, or just maybe they want hiseki employment because it's easier to get. I think a lot of times it's because families, well, the responsibilities would fall back onto families in Asian countries if it's not provided correctly, if we don't have the support in place in the society. In fact, in the last, I think before the last amendment of Special Education Act in Taiwan, we still have parents, they demanded to have spatial schools set up rather than having more inclusive education in Taiwan. And I think that's because they don't see any other options. So I was wondering, from your point of view, what do you think? How can we partner better with families? How do we find that passionate insiders and trusting allies?
Easy question, right? Professor Chung, would you like to take a first stab?
Well, it's not very easy to change social cultural practice. But my sense is that, as you mentioned, a lot of community support are not in place. Also, maybe, so you can see the worries of parents. So the first step for me might be you start to be, start have more community support, not necessarily only community support, also like support in the school. So that would make parents feel more comfortable. And the second thing is, I think some kind of dialogue or training with parents are important. I think DPO they start to do that as well. That they start to have that kind of forums or talking to the parents. A lot of times, those parents doesn't really know what their children thought, and that's something to do about Asian parents as well. They always say they can decide whatever they want to do about their children, right? But nowadays, I think young generation parents are more liberal and they start to see the needs to listen to disabled persons, not necessarily from their children, but from other DPOs. And I can see the progress I'm making there. Yeah. So
Mayuko, would you like to
Yeah.
answer the question also?
Yes. I talked about the employment system, but before employment, children need to be trained as a worker. So, officially transition programs to work is provided, but it's not enough. You know that. So the family care and especially mothers need to train or educate their kids with disabilities, or to be socially adaptable. So I met some mothers who support their kids with disabilities, especially intellectual disabilities, for transitioning to work. Very, very, strongly supported. So.
Yeah, I think it's a good point also about the gendered division of families within the family support structure. So we have a question from online. This is from a PhD student in Taiwan with a physical disability. His name's Francistek Milan. He says, as a foreigner, I'm often dependent on the help of a personal assistant. for most of the time since I came to Taiwan together with an assistant from my home country. But recently I've come into close contact with a local assistant providing organizations for persons with disabilities. I think such organizations like the community support that you were talking about deserve much more promotion in society. How can we raise awareness about such community support?
Well, it's not easy questions to answer, but I think we need more successful stories. Yeah. Nowadays, a lot of campaigns are more based on tragedy or very pitiful stories. So we probably need more successful stories to convince the society that, well, people live independently or live in communities, not only about the needs, support to have a basic quality of life. They can have a meaningful life and or a different lifestyle, like engaging in work in community or in school. So that's my thought. I'm probably not in position to say much, but yeah, if there's anything I can recommend, that might be it. Yeah.
Okay. I'm going to take one more question from the room, and we have a question online as well.
Hey, Richard again, Assistant Director of Seeger Center. I wanted to maybe following up on the last question a little bit more, Professor Zhang, what are some of your observations in Taiwan about different ethnic or religious or minority groups in Taiwan as well? That are there similar social movements or attention across, for example, indigenous communities in Taiwan or other migrant communities or linguistic or other social minorities in Taiwan as well? Or the research that you've seen so far is more concentrated in certain areas or communities over others? Thank you.
Thanks for the question. I have another project. I'm supposed to finish the writings on indigenous people with disabilities. And the answer is they don't know anything about CRP at all. I mean, it's a very urbanized, middle class oriented movements. So well, I think a colleague of mine write another piece about this, that, rights-based ideas is not even an issue in indigenous people's communities. And my argument is a bit different because now half of the indigenous population actually live in urban area. So you actually see the very mixed reaction to human rights models, and people born in different places receiving indigenous people with disability born in different places receive different kind of service, have very different kind of identity and a way to approach these issues. So for me, it's very fascinating because a lot of discussion on intersectionalities, but my research told me that it's not necessarily intersectionality. It's about dual identity or they only have one identity, exclude the others. I think some research on New Zealand and Australia say about this, like indigenous people were placed in institutions, they lose their indigenous identity. But if they are in indigenous community, they don't have native idea about modern concept of disabilities. So so you see different location perceive two identity differently. That's my primary findings.
We are almost out of time, but I'm going to take the moderator's prerogative and ask one more question. This is from Fengming Chui at the Harvard Law School Program on Disability. This is for you. She says hi. Good to see you virtually. In a social environment in which responsibilities of taking care of people with disabilities fall mainly on families, it's even more important to strengthen diverse and strategic alliances among parent organizations and self-advocacy groups for a longstanding social movement for family support without compromising the rights of persons with disabilities in supported decision-making and self-determination. Are there ways, examples from the Taiwanese context that you think have worked well that other countries in East Asia could learn from?
Thanks for me. Long time no see. Are there? I don't know. There are some dialogue between different groups starting from like few years ago, but a lot of times it's really difficult because for self-advocates, the community service are kind of emergency. They needed to have independent livings. So it's hard for them to talk to those parents groups, insist that we need institution to our elderly children. But in a way, there are multiple diverse programs developing now. So as part of the reason, I see maybe we need a procedure or graduate approach to CRPDs that you allow those Asian parents with their children who never received any independent living trainings have a place to go, not solely relies on the parents. And then you can have younger generation have more service in place and make a dialogue or like right-based approach come possible. Yeah.
Thank you very much. Reiko, did you want to add anything on this? I will just flag, Reiko has done some really interesting research about creative solutions to employment situations by particular private companies. So if you want to talk to her about that during the break, please do. But please join me in thanking our panel today.
Right, welcome back and thank you once again, everyone. It's now my privilege to announce our final two speakers. Our first speaker is Kawashima Satoshi, a professor of disability law and an advisor to the president of the Open University of Japan. He received a Doctor of Laws degree from Niigata University in 2005. After being an Okayama University of Science professor, he moved to the Open University of Japan in 2023. He has published over 50 articles on disability law and disability studies in Japanese, and is a contributor to and/or co-editor of over 30 academic books in Japan. He is a board member of the Japanese Society of Disability Law, the Japan Society for Disability Studies, the International Human Rights Law Association of Japan, and the Association on Higher Education and Disability of Japan. He is a member of several committees of governmental and semi-governmental organizations. Our second speaker on this panel is Celeste Arrington, the Korea Foundation Associate Professor of Political Science and International Affairs at GW. She is the director of the GW Institute for Korea Studies and co-director of the East Asia National Resource Center. She specializes in comparative public policy, law, and social change, lawyers, and governance, with a regional focus on the Koreas and Japan. She's also interested in Northeast Asian security, North Korean human rights, and transnational activism. Her first book was Accidental Activists, Victim Movements and Governmental Accountability in Japan and South Korea. She has published numerous articles, and with Patricia Goad, she co-edited Rights Claiming in South Korea. Her next book, forthcoming in Cambridge's Studies in Law and Society series, analyzes the legalistic turn in Korean and Japanese regulatory style through paired case studies related to tobacco control and disability rights. She received a PhD from UC Berkeley and a Master of Philosophy from the University of Cambridge and an undergraduate degree from Princeton University. She has been a fellow at Harvard, the Institute for Advanced Study, Princeton, and the Ludwig Maximilians University in Munich. GW's Office for the Vice President of Research awarded her the 2021 Early Career Research Scholar Award, and her article with Claudia Kim won the 2023 Asian Law and Society Association's Distinguished Article Award. So please join me in welcoming our next two speakers.
Hi, thank you, Lisa, for your introduction. I'm honored to be with you today at this conference on one of the finest universities in the world. And thank you very much for inviting me to this great institution. And let's get started. My title is Some of the Challenges in Legal Advocacy for Disability Rights in Japan. Question is, what is the purpose of my presentation at this conference? Is to identify some tensions inherent in the implementation of the CRPD. So the tensions is my keyword today. And it's very difficult problems to solve. So first, I'd like to introduce basic information on Japan. The total number of PWDs is approximately 11 million. That's a 9% of Japan's population. As you know, Japan's population has been declining in recent years. It's currently around 120 million, but 4 to 19 million by 2060. The increasing elderly rate is now 28%, but to be 38% by 2060. So let's go to my presentation topic. The first, I'd like to mention the CRPD committee's concerns. The committee is concerned about limited awareness of the rights recognized in the convention among the judiciary and justice sector, professionals, policymakers, and lawmakers, etc. In the concluding observations 2022. So, greater legal advocacy is required to ensure the exercise of the rights established in the CRPD. However, I think there are fundamental tensions inherent in the implementation of the CRPD. I will identify these tensions, mainly three tensions. I want to focus on the positive aspects of Japanese disability law. The CRPD committee welcomes as well. It's the human rights dimensions such as non-discrimination and non-abuse against persons with disabilities. So, the Japanese disability law has undergone significant development in the 8-year process leading up to the ratification of the CRPD in 2014. First example is the amendment to the Basic Act for Persons with Disabilities. There are 4 examples of positive aspects of it. Shifting the definition of PWDs from the medical model to the social model of disability. Providing for the opportunity for PWDs to choose where and with whom they live. Obligating the provision of reasonable accommodation. And providing for inclusive education wherever possible. So let me introduce the other examples of positive aspects. The Act on Prevention of Abuse of Persons with Disabilities, prohibiting abuse of persons with disabilities, and stipulating prevention and early detention of the abuse. Enactment the Act for Eliminating Discrimination Against PWDs. Prohibiting discrimination, including denial of reasonable accommodation. It's important to note, in Japan, reasonable accommodation is a kind of discrimination. Reasonable accommodation is a kind of discrimination concept, but the amendment to the Act for the Promotion of Employment of Persons with Disabilities, although it prohibits discrimination and obligating reasonable accommodation, but it doesn't denial of reasonable accommodation a concept of non-discrimination. So then, negative aspects of Japanese disability law. Question is, what are the challenges facing legal advocacy for disability rights in Japan that the CRPD committee is concerned about? For example, segregated education and employment, involuntary commitment to psychiatric hospitals, denial of legal capacity, and backlash against affirmative action. So the first example is the sheltered workshops. The CRPD committee expressed concerns for the segregation of persons with disabilities in sheltered workshops. However, the number of sheltered workshops, especially type B, is increasing in Japan from 10,000 in 2018 to 13,000 in 2022. And most practitioners and academics support segregated employment, that is, sheltered workshops, because PWDs themselves choose sheltered workshops. And the similar example is the special education in Japan. The committee expressed concerns for the perpetuation of segregated special education of children with disabilities. Segregated special education could be seen as a form of discrimination in terms of the CRPD. However, the number of segregated special educations has increased by 1.2 times, and the number of segregated special classes has doubled over the past 10 years. The Japanese government insists that EWDs themselves choose segregated education. Most practitioners and academics support segregated education in Japan because it is a choice of PWDs themselves. The other example is hospitals, psychiatric hospitals. The committee expressed concerns for legislation that allows the involuntary commitment to psychiatry hospitals and the involuntary treatment of persons with disabilities. The involuntary hospitalization could amount to discrimination against persons with disabilities according to the CRPD committee. However, the Japanese government insists that the involuntary hospitalization of PWDs is permitted not just based on disability, but also another reason. They are at risk of harming themselves or others. Also, they need medical protection. And most practitioners and academics also accept involuntary hospitalization for similar reasons. That's a real phenomenon in Japan. The next example is legal capacity. The committee expressed concerns for legal provisions that deny the right of persons with disabilities to equal recognition before the law. The adult guardianship law restricts the legal capacity of PWDs. However, the Japanese government has justified the law as a last resort by arguing that the restriction on legal capacity stems from the need to protect them. Most advocacy lawyers and academics also accept limitations on legal capacity as a last resort to achieve the best interests of persons with disabilities. It's a kind of paternalism. And the last example is the affirmative action. The committee recommends that Japan reinforce affirmative measures and incentives to encourage and ensure the employment of persons with disabilities. Most practitioners and academics support affirmative action such as employment quota and priority hiring of PWDs to actively promote the social inclusion of PWDs. However, persons without disabilities criticize that they are in part being, it's one example, they are in part being restricted from establishing new massage training schools because of preferential treatment for persons with visual impairments. So the CRPD committee's concerns and recommendations indicate Japanese disability law restricts the CRPD rights. But interestingly, this restriction is accepted as inevitable not only by the Japanese government, but also by most advocates, including practitioners and academics in Japan. In my opinion, one important reason for this is the fundamental tensions inherent in the implementation of the CRPD. Legal advocacy for disability rights in Japan faces at least the following tensions inherent in the implementation of the CRPD. Personal autonomy versus social inclusion. Personal autonomy versus best interests. Affirmative action versus positive attitudes. I explain these tensions for now. The personal autonomy versus social inclusion. Individual choice, it's a kind of personal autonomy, is at the heart of human rights, yet can sometimes lead to the exclusion of persons with disabilities. As mentioned earlier, PWDs who choose segregated education or segregated employment decide not to participate in mainstream society on their own will. Advocates therefore have no choice but to tolerate segregation. However, in my view, it's significant to provide PWDs with access to mainstream education and employment that they would like to choose. Removing the barriers that prevent this is one of the challenges for advocates. Second tension is the personal autonomy versus best interests. It's a kind of paternalism. Protecting the best interests of PWDs has been supported by most advocates in Japan, but limits the personal autonomy of PWDs. Advocates tend to prevent PWDs from making poor decisions for themselves. However, in my understanding, it's significant that advocates do not force their decisions on PWDs, but rather support PWDs in making decisions to avoid the wrong choice by themselves. And the last example of tension is affirmative action versus positive attitudes. Affirmative action contributes to the inclusion of PWDs in society, but can also lead to stigma and social backlash against PWDs, undermining positive attitude towards them. However, the CRPD message to advocates would be that both PWDs and non-PWDs need to bear the burden of the problems of affirmative action until full inclusion of persons with disabilities is achieved. It's a sunset clause until the full inclusion. In conclusion, the challenges in legal advocacy for realizing the disability rights in Japan is how to deal with these three tensions: personal autonomy versus social inclusion, personal autonomy versus best interests, affirmative action versus positive attitudes. Effective implementation of the CRPD required that both the Japanese government and legal advocates address these tensions appropriately. But it's so difficult. As you know, it's a tensions between idealism and realism. So I don't know how to deal with these tensions now. So it's my real conclusion. Thank you very much.
I have the unenviable honor of standing between you and lunch today. So thank you for staying to the bitter end. So it's humbling to follow after the 5 previous presentations. But I hope that some of my remarks today will give you a sense of how disabled activists and allies and lawyers are trying to navigate some of these tensions that Kawashima Sensei just mentioned in the implementation of the CRPD. My talk today draws on my forthcoming book. So this is a moment of shameless self-promotion. This book is coming out in June. And in this book, as Lisa mentioned in introducing me, I'm documenting a legalistic turn in regulatory style. So that is that laws are becoming more detailed and more enforceable and can also be used more effectively in court. And there are more formal or proceduralized and participatory policy design and policy implementation procedures in Korea and Japan. So one of the issue areas, as you can see in part 1 of my book, that I document this legalistic turn with is disability rights. And so today's talk will draw on that first portion of the book. Disability rights in particular shows us a variety of different indicators of legalism. So how do we know legalism when we see it? What we're seeing is more detailed and formal rules, more codified rights, more sanctions or other fines and enforcement mechanisms for rule breaking, more participatory policy design and implementation, and more proceduralized enforcement, including via the courts. Historically, Korean and Japanese governance relied more on informal, non-binding measures and closed-door bureaucratic policymaking. So this shift marks a change in the way governance is happening in Korea and Japan. To describe this change, I draw on the work of Bob Kagan, and he describes legalism as having 2 main dimensions. Regulatory style, he says, is the who and the how of policy decision-making, policy implementation, and policy enforcement. And so in terms of the who and the how, one dimension on which regulatory style varies is how formal is it. So how detailed or written down are laws and rules? Are decision makers following pre-existing rules and procedures, or are they responding in a flexible way? The second dimension is the level of participation. So are decisions being made by bureaucrats in closed-door rooms, or are they involving the 당사자, the Tōjisha, the affected parties in the decision-making process? These 2 dimensions help us to clarify what's changing in a world in which many scholars have said politics is becoming judicialized or legalized. So let me make this a little bit more concrete with some disability So basically, this is what my book is arguing. Very scientific graph here for all of you political scientists out there. We are seeing a shift in the way governance is done in Korea and Japan. Let me make this a little bit more concrete with some disability-related policies. So previously, Korea and Japan, people with disabilities had to rely on the good intentions or the assistance from, for example, from station staff in Japan in order to use public transportation. And many people with disabilities or disabled persons organizations have argued that those good intentions were not enough. So for example, in protesting in Korea, disabled persons also want to ride intercity buses. As Sooyeon mentioned earlier, very few of them are accessible to people with disabilities. However, in the last 20 years one more point. This man also appeared in Sooyeon's presentation earlier because he's heavily involved in the mobility rights protests. But people with disabilities argued that because there are not legal requirements for the accessibility, say, of cafes like Starbucks, they can't get into the cafe, and this is a violation of their rights. And the solution was to make accessibility accommodations legally obligatory, or 의무화 in Korean, or 기무화 in Japanese. So in Korea in the last 20 years, this is a brief synopsis of some of the many legal changes that have occurred. But the main policy council for disability rights policy is now required to have people with disabilities on it. In addition, in 2005, a new law was passed that codified for the first time a right to mobility, or 이동권. There's also a right to accessibility in Korean law now, legally defining what discrimination, disability-based discrimination was passed in a law in 2007. That law contains a variety of detailed contexts in which disability-based discrimination could occur. And it also specifies if you experience disability-based discrimination, where do you go? So the remedies via the National Human Rights Commission of Korea, and if that doesn't work, then via the courts. In addition, laws about the accessibility of buildings and public transportation facilities have become not just guidelines, but legally binding. Since 2022, for example, any building that's over 50 square meters now has to be publicly accessible. And the committee that evaluates the accessibility of buildings is now by law required to include persons with disabilities on it. So this is not just more formal rules, but also more participatory policymaking. In Japan as well, we've seen somewhat less of a legalistic turn, but people with disabilities are now also required to be on the policy councils. And since 2016, when the 2013 Disability Discrimination Elimination Act went into force, public entities are required to provide reasonable accommodations to people with disabilities. And since last year, private entities are now also required to provide reasonable accommodations. Transit facilities and buildings have also gone from having guidelines about their accessibility to having binding rules requiring accessible facilities. In Japan, we have now regional disability discrimination elimination councils, and 90% of them include a person with disabilities included a person with disabilities by 2018. Interestingly, there's most of those do not include a woman with disabilities. And to Reiko's point about employment, many of those people on the councils have physical disabilities, and people with intellectual and cognitive disabilities are much less represented on these policy councils. In Japan, there's also a mobility promotion assessment committee now, which by law has to include persons with disabilities on it as well. And even training programs to cultivate barrier-free mindsets, or kokoro no barrier-free, are legally obligatory. So the training programs also became obligatory. Now, while I cannot detail all of my book today, you certainly don't want to hear everything. I'll just briefly give you a synopsis. My argument is that activists and lawyers are key change agents behind this legalistic turn. And they're doing this by not only helping to change the laws, but then actively using the laws to deepen the laws and make them more meaningful. And in the process, they're changing regulatory style and the way governance is happening. Okay, so one of the key ways in which activists and lawyers are doing this is by providing information subsidies to lawmakers, to judges, and also the broader public. And I think this really resonates with the first panel from today. Sooyeon and Mayuko's presentations gave a lot of other examples of information subsidies. But information subsidies is a concept that I use in this book, and that is that policymakers have limited time, staff, expertise, and they therefore benefit from disabled persons organizations and lawyers shouldering the burden of doing the research, recommending specific policies, bringing the information to them, that then provides a subsidy that makes them more likely to propose legalistic policy solutions. So because of the limits on time and knowledge of policymakers, civil society actors actually have an opportunity to influence policy because they can collect and analyze and package information. Keck and Sikking, for example, have written about this as they called it information politics, and they said that civil society actors that have the ability to quickly and credibly generate politically usable information and to move it to where it will have the most impact. That's a very similar concept to information subsidies. So for disabled persons organizations and lawyers, they might, for example, research a particular problem that has not received attention. They might also research, as Mayuko talked about, policies that have been tried elsewhere and provide good examples. In many of the specific legislative changes that I studied, activist groups ghost wrote, or they actually wrote the clauses that ended up being in the laws, and thereby providing information subsidies for lawmakers. In addition, in legislative debates or in court cases, they provide not just expert testimony, but the personal stories of having personally been affected by a particular lack of regulation. And then after the law is passed, they then might test the new regulations and see where there are loopholes, remaining loopholes, and help close the gaps. For disabled persons organizations participating in policy making in these new ways that are available to Japanese and Korean organizations has increasing returns. So by participating, they come to better understand the logic of policymakers, what kind of information they're looking for, and then can craft their information subsidies to be more effective and more impactful. They also, by participating in policymaking, gain credibility in the eyes of policymakers. And so when policymakers or their staff are looking for experts to invite to testify in legislative debates, they automatically think of those disabled persons organizations. This process really fits with the global frame of nothing about us without us in disability rights activism, and that emphasizes that disabled persons have expertise as users of accommodations or as affected parties. And this links back to Mayuko's earlier presentation. Information subsidies are not just useful at the agenda setting and the legislation making stages, but also in implementation and enforcement. And so closing loopholes and not just campaigning for changed laws, but actually actively using those laws are a key way in which information subsidies are making rights real. So let me give you a couple of examples from Korea and Japan. So for example, in 2007, Korea passed the Disability Discrimination Prohibition Act, and lawyers organized public hearings with disabled persons organizations all around the country. In 2003, 65 disabled persons organizations in Korea formed a solidarity organization for a new Disability Discrimination Prohibition Act. And within that solidarity, they formed a legislation committee. So this committee was tasked with designing a proposal for a new law. According to the lawyer who led this legislative committee, there were two core principles. The first was that we need to include the actual voices and needs of people with disabilities in the draft law that we write. And the second was that disabled persons need to be involved in the drafting to build their capacity. And one activist who participated in the process said that she felt like this process really turned disabled persons from passive consumers into producers or leaders in the policymaking process by having a seat at the table and a role in the process. This legislative committee was not the only thing going on. There were also, as you might expect in Korea, protests out in the streets, extensive ones. But the draft that this legislative committee produced was proposed in the National Assembly by a small left-wing party. It had very little chance of passing, and indeed it did not. But when the Blue House, the Presidential Committee on Social Inclusion Task Force for a Disability Discrimination Act convened, they used that draft that had been written by the Solidarity as a starting point for deliberations. And many of the people who had been a part of this legislation committee were actually on the task force as well, both disabled persons and lawyers. And so they used this draft as a starting point, and much of it became, not all of it, but much of it became law. If we shift gears to Japan, there's a similar example. The Japanese activists were not able to push through the desired revisions to the basic law for people with disabilities in 2004 that they had wanted. But they realized that we need a legally binding law that we can actually use during a trial when a problem of discrimination actually occurs. At the national level, they faced a lot of resistance to a legally binding law. And so they turned to Chiba Prefecture, which enacted, this gets back to Richard's question from earlier about local activism. There were a number of individuals in Chiba who were more receptive to this idea. And what disabled persons organizations and lawyers did was like in Korea, they held public hearings and collected actual cases of discrimination from a variety of different fields, which they then categorized into 8 potential contexts of discrimination, and those were then directly included in the ordinance text. They also created a consultation and dispute resolution committee, which has clear procedures. Chiba's ordinance has inspired a variety of other local ordinances in Japan. In 2013, as we mentioned, Japanese activists achieved a Disability Discrimination Elimination Act finally, and it went into force in 2016. It was not everything that the activists had wanted, and so some of the lawyers got together and made a practical manual about how to actively use the law to make it more meaningful. And one of the key problems that they noted was that the Disability Discrimination Elimination Act, instead of allowing remedies through the courts, requires Japanese victims of discrimination to go to consultation offices, or sodan madoguchi, in the relevant ministry, and consult with them to try to resolve the discrimination problem. They noted that Chiba and other local ordinances had more clear remedies than the national law. In order to show how these consultation mechanisms were not enough to make rights real on the ground, they launched with DPI Japan a campaign that was called Sodan Madoguchi o Tsukatte Miyo. Like, let's actually try to use these consultation offices. And it's a very confusing mess of, like, if you experience discrimination in one context, which ministry do you go to consult? And if you go to the wrong one, they'll just pass you along to other ministries. And so there's a lot of passing along of complaints of discrimination. DPI Japan, so Disabled Persons Organization, collected examples of how this was not remedying discrimination, and helped to provide impetus for a one-stop portal. So now online, it's a little bit better. You can file your complaint about discrimination to one place, and then it gets distributed out to the appropriate office. In addition, organizations like DPI Japan tested the proposed regulations about accessibility, and some of this was very low-tech, so literally saying the regulation specifies how wide a hotel room entryway should be, and so they used boxes in their office to show that regulation would work for domestic wheelchairs, but not foreign wheelchairs. And this was in the lead up to the 2020 Olympics. And so if you're going to have foreign athletes for the Paralympics come to Japan, but then not able to get into a hotel room, that's a little bit problematic. As a result of these types of information subsidies, the regulations about hotel rooms were changed to allow for wider foreign wheelchairs. Another key way in which lawyers and activists have mobilized information subsidies is through strategic litigation. In Korea, there's a very interesting and important case about the accessibility of small stores. And this case was filed in 2018 against the largest convenience store, hotel, and cafe chains, alleging that the exemption for small stores was unconstitutional. From 1998 until 2022, any store that was smaller than 300 square meters, which is actually pretty large, was not required to be accessible. And that regulation had been in place for 24 years. The Supreme Court ruled in December, which was an interesting time in Korea, as Sooyeon mentioned earlier, that the state's failure to revise that ordinance, that implementation decree, was illegal and discriminatory. So the Supreme Court ruling last December was really historic. For the first time, it found that legislative inaction was unconstitutional. During this court case, the plaintiffs and lawyers and supporting disabled persons organizations conducted surveys of convenience stores around the country and found that 95% of convenience stores were not accessible, for example. And that survey was then cited in the Supreme Court ruling as part of the justification for finding this unconstitutional and discriminatory. They also used the phrase here, life on the first floor, or 일층의 삶, which harkens back to labor rights activism. Labor rights activists talked about life with dinner, so like the ability to have dinner, and they therefore mobilized support. In addition, the lawyers and activists in this court case filed information subsidies to the UN CRPD parallel reports, and the 2022 and 2014 concluding remarks at the UN Committee on the Rights of Persons with Disabilities both mentioned these size-based exemptions as being contrary to the CRPD. In addition, the cause lawyers, or the activist lawyers who are involved in this court case, have partnered with a foundation to not just support the lawsuit and raise awareness, but to make actual change. So they are providing subsidies, both informationally and monetarily, to local businesses to install ramps. And the Public Interest Law Foundation, Turu, spearheads this non-litigation project, which is emphasizing that it's not just people with disabilities that benefit from such ramps being installed, but also elderly people who comprise a large portion of the population now, and people with strollers. As I mentioned, the Korean Supreme Court ruling last December was historic. It found for the first time that Articles 10 and 11 of the Constitution affirm the dignity and equality of all citizens. And then even though in the Constitution that is not explicitly written to include people with disabilities, the state must actively ensure disabled persons' rights and include accessibility as a prerequisite for the free and independent exercise of rights. So this ruling has the potential to have a great impact. And if you know what's been happening in Korean politics recently in the National Assembly, it's very divided, but the parties, opposition and ruling parties, actually came together in January to discuss, after this ruling, how do we then make accessibility rights real on the ground? Where do we go from here? How do we realize life on the first floor for everyone? Part of the reason why this lawsuit has been so effective is the public interest law firms and foundations which have flourished in Korea. Many of them make disability rights a specific practice area. And these entities do not exist in the Japanese context. They're more ad hoc and pro bono in the Japanese context. But in Korea, there are now law firms and public interest law foundations in the very large firms who have the money, the time, and the attention to devote to disabled persons' rights. And one of the ways that you can see this is, I think, Sooyeon, you mentioned also being contacted to write a manual. So for the judiciary, the judges have asked one of the public interest law foundations, Turu, to study the accessibility of courts and to go around and find out whether the courthouse itself is accessible, but also whether the information in the judicial proceedings is accessible to persons with disabilities. And because these organizations are visible and recognizable and have staff, now they have the resources to be able to more effectively write such manuals. So let me wrap up here that over time, these information subsidies and strategic litigation have contributed more broadly to a legalistic turn in governance. But the way in which disabled persons organizations and allied lawyers, including some lawyers with disabilities more recently, have been doing this is by mobilizing information to where it has an impact. So together, people with disabilities have the authenticity and the legitimacy, and lawyers can help bring some of the legal expertise and the know-how to make information subsidies more effective, to meet the information logics of policymakers. And as change agents, they're not just transforming the legal frameworks, but they're also using those new legal frameworks to deepen them and make them more meaningful and to change disability rights on the ground in the real world. So that's my presentation. Thank you. Now I get to moderate ourselves. All right, thank you for listening. I want to open it up to questions from the audience, and we also have a couple of questions online.
So first of all, thank you to all of the speakers today for your scholarly contributions and your advocacy for individuals with disability, and of course for enlightening us here today. The fact that there has been this shift to legalism and intention between competing principles within disability legislation demonstrates that you truly are making the world a better place for more people. My question's for Dr. Arrington, and it relates to something that Ms. Lee talked about before. When I lived in South Korea, I was quite impressed by the activism that I witnessed by individuals with disabilities. Despite limitations with mobility, they were out on the streets, largely on their own initiative with very little help from others. And so I was interested in hearing more about what advocacy organizations are seeking with respect to how the police deal with individuals with disability who may block traffic as part of their activism. Back during the Iraq war protest in the United States, that occasionally spilled over into marches that blocked traffic, I remember how shocked some of us were when the police pepper sprayed an activist on crutches. He may have just been temporarily disabled, but clearly he was more vulnerable than others with the consequences of something like pepper spray. And so with that in mind, do you think the preference among the organizations that Ms. Lee is part of is for equal treatment to prevent people who are much more vulnerable to police responses from being targeted or placed more at risk? Or is it more about extra care when dealing with acts of civil disobedience?
Thanks, Peter. Sooyeon 변호사님, do you want to address this question? Because you mentioned the effort to raise awareness about police treatment of people with disabilities at the ICCPR.
Actually, nowadays I have lots of cases about the kind of cases, and our claims are, I think, the police and some kind, the government's side, when the government changes and politician changes, how they treat is different. And so I think we insist that there is some human rights or disability rights education should be conducted, but they say we do some educations or some kind of awareness, some raising things, but it is very formal and some not effective things way they conduct it. So in that case, I have to. There is the point when the instructor should be some persons with disabilities or some activists because they explain what's going on and what's the rights of them and what is the important things in some protecting rights or people. So, but yeah.
Yeah, thank you very much. I'm going to shift gears to a question online. Most of the topics today, this is from Yingji Dai, have been about physical accessibility and protections for people with disabilities in terms of legal access and representation and physical access. So this person was wondering if any policies or movements have been expanded to include digital and web accessibility or information accessibility. Additionally, are there existing protections and legal requirements for making the web accessible to those with hearing, vision, and intellectual disabilities? Awashima-sensei, do you want to talk about the Japanese case?
There is a new law on the information accessibility. So I have no idea about case law, but the new Information Accessibility Act expected to make the human rights real, but it's just accessibility law, not actually human rights law. So we cannot use this at the court, but we use it via the mass media or social movement as a social movement. So we should use a variety of channels to CRPD rights real.
To make them real, yeah. In Korea, also, there are a number of disabled persons organizations, including some that used to emphasize physical accessibility. Especially since COVID, we've seen the spread of kiosks for paying, for example, in cafes and convenience stores. And they're particularly targeting the manufacturers and the managers of stores that use such kiosks to try to make them more accessible to persons with disabilities. So there's almost like a shift. They're using some of the know-how that they learned by improving physical accessibility to now shift into information accessibility. I want to take one more question from the room.
Hi, my name is Chandra. This question is, I guess, could be answered by both of you, but specifically focused on Kawashima Sensei. You mentioned this medical versus social model, which is a really important shift to make, but I was interested in hearing what your recommendations are in improving disability cultural competence among society as we move beyond the CRPD, please.
Thank you. Very good questions and important one. I think the education is important, so many persons say, because some of the people or lots of people in Japan don't know persons with disabilities. So because it's separate education, I think elementary school is especially important to combat discrimination. And the social model is not known in Japan, actually. So only very limited area, especially DPOs, among DPOs, but many Japanese people don't know what is social model. So it's important to introduce social models philosophy in the elementary school. It's my point.
I think this point about increasing the visibility and the presence of persons with disabilities in society. I mean, one goal is full inclusion in society and participation, but also being able to meet people with disabilities and experience them. And as Professor Chang mentioned earlier, have the positive stories to hear, as Mayuko mentioned earlier, the direct voices of the affected parties, how they experience and how they live out their lives with disabilities is very important in raising and changing public awareness about disabilities. And part of what helps that presence in society is changing rules and regulations about the accessibility of the physical space, or providing new and creative ways for people with disabilities to be employed, as Reiko mentioned, or to participate in education in a variety of different ways, or to exercise their right to vote and to be more a part of society. But I want to thank all of you for joining us today, and please join us for lunch after this as a small reward for sitting through many talks. But thank you all for your questions and your participation in today's workshop. To those who are joining online, I'm sorry we can't feed you. But please join me in thanking Kawashima Sensei and the other speakers today.